Major Dynamics presents Winning Moot Court Competitions, Techniques to Excel, an educational seminar presented by Scott Major. A well-respected and highly accomplished attorney, Scott Major is the driving force behind Major Dynamics. His credentials as a trial and appellate attorney, his participation in appeals at both the state and federal levels across the country, and his winning experience in freshman, regional, and national moot court make his educational seminars interesting, insightful, and right on the money. But it is his witty and energetic style that makes him consistently the highest-rated lecturer in Florida bar history in his category. It is this enthusiasm that has garnered rave reviews for his national and local seminars and legal work across the country. And it is the combination of all of these attributes that make this seminar on moot court the most valuable supplemental source available to help prepare you for any oral argument in school or in practice.
May it please the court. My name is Scott Major, and I'm here to take you on a journey through the first year moot court oral argument. It's an experience that we all have to go through. It is hoped that this video will take you step by step through the moot court oral argument. The topics that we intend to cover are the following. What is moot court? What should one expect in the moot court experience? How do we score? What kind of preparation is necessary in order to have an effective moot court argument? How do we open? The presentation aspect, that is the body of the argument. How to close, the rebuttal, strategic tips, and then we'll recap so that you can get an understanding of what we've been through. What is moot court? Moot court is a chance for you to present an oral argument to a panel of 1, 2, or 3 judges. It gives you an opportunity to combine that written product that you've done, which is similar to a law review article, with the oral aspect of it, which is similar to a trial competition. It is the quintessential opportunity in law school. What to expect? Let's discuss the players, the battleground, and some of the attitudes that you need to overcome in performing the moot court oral argument. Let's look at the map, shall we? In position A over here, we have the enemy, the appellee, or if you're the appellee, the appellant. Up here, we have the judges, sometimes perceived as the enemy, but really the ally. Then we have the bailiff, the timekeeper, the person who keeps control of how long the battle will go on. Attitudes. To win the moot court battle, you must overcome the fears and rumors that are inherent in the oral argument preparation. Many people talk to you and tell you how horrible it's going to be and how you're going to be scared out of your wits and they're going to throw hand grenades and shoot you with bullets until you fall down. The reality is, if you come in prepared and confident, you have the weapons of destruction, and you will win the battle. Scoring. This is how we measure the experience of moot court. It's broken into several categories. Scoring is done by the judges, and this is their way of sending you a message as to the merit of your argument. It is broken into categories. Different score sheets have different subsections, but the general sections you should be concerned are evidence of research, performance in answering questions, responsiveness to the opponent's arguments, and forensics. If we look at each one of those sections, we will be able to see how your argument should be molded. Evidence of research. Questions that are often asked of the judges when they're reviewing your argument is, does counsel give a brief overview of his or her argument, including the important issues? Does counsel have a thorough knowledge of the record and applicable law? Were counsel's comments and arguments organized, clear, direct? How does one answer questions? This is one of the most important sections. Do they answer yes or no? When appropriate, did counsel properly respond, or were they evasive? Did you answer yes or no, or did you try to get around that question? And the segue concepts of, did counsel use those questions and answers to bolster their argument, to return back into where they were, so it appears as though you anticipated the questions? Was counsel candid about the weak points in the case, often referred to as the art of concession? Did counsel use reason and logic rather than relying solely on precedent? Have you looked at the policy implications of what you're doing and applied logic and reason to the facts and the law of your case? Did you respond to the opponent's arguments? And that is a response both on the appellee side, when he or she responds to the appellant's argument, and on rebuttal, when you, as the individual, get an opportunity to respond to the appellee's arguments. Did you concern yourself with the policy considerations and what the effect of what you're asking the court to do will have on the decision? Courts are going to ask you that question very often. Counsel, what do we have to do? And those are questions which we're going to deal with. Forensics. Did counsel properly introduce him or herself to the court and identify your client? Did you speak in a clear and concise manner? Did you maintain a professional manner? Or did you become flustered when you were questioned? Did you maintain eye contact with the entire court throughout the presentation, both in your argument and in the questions? When a question comes from the court, it is from the entire court, not just from one judge. Preparation. Knowing your argument, what to bring, and doing your homework. First, knowing your argument. The most important thing about this section is to recognize that you know your argument even better than the judges. This is because you've been preparing the brief for the past 3 to 5 months. And this confidence should give you an air of comfort when you present that argument. What to bring. There are differing techniques as to what information you should bring and what type of system you should have in your presentation. Let me suggest to you a simplified folder system. That is where you take 2 folders, you affix them together, and then when you place them down onto the podium, they provide you with 3 separate sections, and yet the panel will not see it. It is not as important what it is that you place on here, but that you do your homework by placing information which is going to be important to make your presentation concise, smooth, articulate, and responsive to the needs of the panel and those who will be judging you. How to open. Now it's time to begin your argument. You need to have a rehearsed, standard, clean opening that's memorized. I'm going to give you some thoughts on what I think you ought to have in your opening, and then some tactical suggestions you might want to add. May it please the court. My name is Scott Major, and along with co-counsel John Smith, we represent the petitioner, Bill Thompson, in this case. This is very important to let the court know who you are and who you represent. There is no deviation in this type of opening. You then need to ask for rebuttal time. At this time, we respectfully request 2 minutes for rebuttal or 3 minutes for rebuttal. Generally, you don't need much more of the time than that. Now, some judges will have actually on their score sheets a position to see whether you've asked for rebuttal, because as the appellant, the only person asking for rebuttal, you will not be permitted to have rebuttal unless you request it. Now, after the rebuttal, you want to tell the court what you want. May it please the court. My name is Scott Major, and I represent the petitioner, Bill Thompson. At this time, we respectfully request 2 minutes for rebuttal. We ask this court to reverse the decision of the district court and allow Bill Thompson to die in peace. Now, you have two options. One is to combine that prayer, as they call it, that request asking the court to do something, with what is called a hook. Or you can leave it as is. The hook is more of a dramatic, not to be confused with melodramatic, opening that captures the essence of what you're about to talk about. May it please the court, my name is Scott Major. Along with co-counsel John Smith, we represent the petitioner in this case. Respectfully request 2 minutes for rebuttal. We ask this court to reverse the decision of the district court and allow Mr. Thompson the right to make his own medical decisions and thus to die with dignity. Now, this captures the essence of what you're going to talk about. There are two issues before this court. First, the individual has a right to make medical decisions on their own, and whether this right extends to permit the termination of nasogastric feeding tubes, which result in the death of the individual. Now, what I have done is I've given the court an understanding of who I am, who I represent, and where I'm going to go. From that standard opening, we are going to go into the factual discussion. Now, you need to understand that this section must be memorized. You will very rarely be interrupted. So you have the wonderful opportunity to score an exceptional amount of points by having good eye contact, good delivery, succinct, and it's memorized. Practice it in front of a 6-year-old so that they understand exactly what you're asking for. Now, there's a lot of extraneous words that people add into the oral argument, like, now I'm about to go into the facts. Here are the facts. May I state the facts, Your Honor? Don't tell people where you're going. Just go there. On December 5th, 1991, Bill Thompson suffered a massive heart attack. It left him in a comatose, vegetative, and brain-dead state. He sought to exercise that right due all of us under the Constitution, the right to die with dignity. The trial court did not allow him this right and prohibited the termination of life-sustaining treatment. He appealed that decision, and that decision was affirmed, bringing us before this court. Now, I have gone through the entire opening, and I have let the court know a little bit about what I'm going to talk about and the facts which are important in developing that argument. Presentation of your oral argument. Now it's time to take the step from the introduction, the opening, and segue it into an effective presentation of your oral argument. In order to effectively communicate your position, you need to have a command of both the facts and the relevant law, as well as the law which works against you. In the context of your argument, make sure that you are very clear, clean, and that you follow those points which you have itemized in your request. In our given situation, Mr. Thompson wants to terminate life support and die with dignity. I need to establish his right to die. So I've completed the facts. I take a pause and I say, the Constitution gives an individual a right to make medical decisions about their life. This is based upon the right of privacy that came out of the Roe versus Wade case and the Constitution's First, Second, Fourth, Fifth, and Ninth Amendments. The Constitution and the developing case law has extended this right to allow individuals who are in a comatose, brain-dead, vegetative position to make medical decisions terminating their life support. Now, what I've done is I've set up for the panel exactly the legal basis for our case. Now I begin to apply the facts. Mr. Thompson is comatose, brain dead, and vegetative. This has been determined by 3 doctors. Page 27 of the record. Great opportunity for you to inject a record site, collect a lot of scoring points, because what you've done is let them know that you know about the record. Inevitably, in the context of your argument, you are going to be faced with questions from the bench. When fielding pitches from the court, make sure you know the difference between a softball that you can hit for a home run and a hand grenade. Thus, answer every question clearly and directly. Isn't it true Thompson versus Thompson does limit the right under the United States Constitution for those people who wish to terminate life support? Ladies and gentlemen, the answer is either yes or no. Don't give the typical answer. Well, in answering that question, I need to look at Jones versus Jones and Thomas versus Thomas. And it is possible that under those circumstances, that perhaps under those particular facts and not distinguishing those facts from the other facts, well, what was the question? Answer yes or no. Then you can explain. And understand that that judge may be asking you that question to help him or herself, or to get the rest of the panel to agree with them. Isn't it true Thompson versus Thompson limits the right of the Constitution? Yes. That takes us into the art of concession, too. Because what it allows us to do is to answer the question in what you would think is an unfavorable way, but really it helps you. Yes, Your Honor, there is a limitation. But that limitation does not extend to prohibit Mr. Thompson the right to make medical decisions about his life. And those medical decisions include the right to terminate life-sustaining treatment. Now I've made that segue that we talked about. It is in fact true, Your Honor, that cases like Thompson versus Thompson, Edgar versus Edgar, and the United States Supreme Court case of Smith versus Davis do all stand for the proposition that those rights are not unfettered, that we must establish limitations. But we're not asking for a blanket right to die, Your Honor. We're simply asking for Mr. Thompson to have the right to make his own medical decision. And in this case, that medical decision involves the withholding of life-sustaining treatment. Now, what I have done is I have taken that court's question. I have answered it. I have conceded and used the concession to segue back into my argument. This is the quintessential method for scoring points. This is the way you win moot court competitions. There is no substitute for this transitional response. None. So when you are in your argument, don't be put off, distracted by the judge's questions. Use them as a vehicle to score points. You already know what the judges are going to ask you. There's no secrets here. It is very rare when they ask you a question that you absolutely don't know. And by the way, if they do ask you a question you don't know, the answer is, I don't know. Chances are that question will not be fatal to your argument. If you really feel that a judge asks you a question that is so good, so strong, and so effective that you're very concerned about what the judge is asking, and he or she will just not leave you alone, then use an effective technique called recognition. Your Honor, I understand your concern, but it's not dispositive in this case. Now watch the segue. Mr. Thompson is merely asking for the right, the small right that is inherent in the Constitution of the United States of America to make a medical decision. It so happens in this case that medical decision results in his death. But that's not the issue before this court. The issue before this court is whether he has the right. And the law and the Constitution gives him that right. Now, I have then taken a simple question and made it a weapon of destruction for not only scoring points, but against that other side, because the other side is going to get up and have to respond to that. You need to now to make sure that you've applied all of the facts of your case. Don't just argue the law. When I mentioned earlier about applying facts, make sure the court knows that in this case, we have certain facts which, when combined with the law, will result in a favorable decision, and that this decision won't hurt you. If you do that, then when the appellee gets up, what you have done is you have poisoned the well. You have placed the hand grenades with the pins out, waiting for him or her to now have to deal with this minefield. Because when they get up, they're going to get up and say, there's no constitutional right to die. And what do you think the panel's going to say? The panel's going to say, well, counsel, didn't the appellant just get up and say he recognizes it's not an unfettered right, that there's only a limitation on the right? Oh my goodness, now that person is on the defensive. And that's the job as the appellant. The appellee has to make sure when he or she gets up that they're going to respond to those contentions. The appellee needs to listen intently to not only what you as the appellant argue, but what the judge states, what the judge asks, what the judge is concerned about, and use that against the appellant. As Justice Thomas aptly pointed out, the Thompson versus Thompson case does provide a limitation. And that limitation in this case, contrary to what has been asserted by the appellant, does restrict the right of Mr. Thompson to terminate his life. And this is because Mr. Thompson can't terminate his life because he's comatose, vegetative, and brain dead. Mr. Thompson wants somebody else to terminate his life. And that's where, as Your Honor has aptly noted, Thompson versus Thompson restricts a third party's right to do it. Your Honor, this case is not about a person's right to make medical decisions. It's about whether a third party can commit murder, whether a third party has the right to unilaterally decide when somebody should die and not die, to make quality of life judgments that has never been contemplated by the Constitution or any case that has ever been come down from the United States. Look what I've done with the appellee's argument. By listening to the appellant's argument, I have made an extremely persuasive argument. And all of a sudden, all of those things which were planted as destructive elements don't become so destructive. That's extremely important in making both the appellant's argument and the appellee's argument. Applying the facts, taking the law, making it persuasive, using record citations, and using the questions of the judge in a conciliatory way to segue into an effective and winning presentation. Those are the things you need to think about in making an argument. How to close. Now you've come to the end of your argument, and you need to wrap it up through the vehicle of an effective closing. It should be memorized, it should be concise, and it should tell the panel what you want. Mr. Thompson has a right to die. That right is grounded in the Constitution of the United States and the accompanying case law. The trial court erred when it did not allow him to exercise that right, and we therefore ask this court to reverse the decision of the lower court and to allow Mr. Thompson to die with dignity. Now, what have I done? I have effectively taken my argument and told the court what I want in a memorized, clean way, and you will score points if you do it this way. Now, you may have the problem of being faced with a stop card. A stop card is not a go card. It is not I'm running low on time card. It is not, please, Judge, please, let me finish my argument. It is a stop card, and you should stop immediately. You may respond, though. Your Honor, I see my time has expired. May I have a moment to conclude? The only other circumstance you might face is if you're in the middle of answering a question. Your Honor, my time has expired. May I have a moment to answer your question and to conclude? If you do this, combined with an effective closing, you give yourself the best chance for maximizing points and winning the moot court oral argument. The rebuttal. The rebuttal is divided into two parts: the appellee's rebuttal and the appellant's rebuttal. The appellee's responsive argument is really a giant rebuttal. Your entire argument should be a response to the appellant's argument. You should listen carefully, lie in wait for the opportunity to pounce on the appellant's argument. Use the judge's comments. Tie those comments in with your argument. Your Honor was correct when he referenced Thompson versus Thompson and its restriction on a third party's right to make medical decisions to commit murder. This is why it's important as the appellee to be very aware of what the appellant's doing. Now, the appellant has the more traditional rebuttal. You've asked for your rebuttal time early, and now you have your 2 or 3 minutes. Use it like a swordsman. You get in and you get out. 1 point, maybe 2 at the most, and sit down. Strategic tips. Here's a couple of tips that I think would be helpful in the moot court argument. First, be conversational. This is not a debate. This is not an argument. It is a dialogue. It is a conversation with the court. Act and be confident. You know more than they do. Don't forget that, and you serve yourself well. It is very important that you show a professionalism like an attorney. Don't make distracting mannerisms, don't nod, don't speak, and rise whenever you're addressed. When should you start your argument? There's an ongoing debate about whether or not when you stand in front of the judge, you should immediately start or say, may it please the court, and wait until the judge nods. I think a good 3 or 5 number count would be a good way of doing that. May it please the court. 1, 2, 3. If they haven't answered, my name is Scott Major, and I represent the appellant. It's a good way of getting the court's attention and not being disrespectful. Next. Your Honor versus Your Honors. Every time you go into a courtroom, you'll have somebody tell you you should be doing it differently. My response, whenever possible, don't address them as either. Either address them by name or just answer the question. Stop when a judge speaks. The Constitution, yes, Your Honor? When this, yes, Your Honor? In the middle of a syllable, if you need to stop. Because that judge controls your destiny. Individual versus team competition. Sometimes you'll be paired with people. It's a good tactic to get to know what your cohort's particular argument is so that you can say, along with John Smith, we represent the petitioner. Or, there are 2 issues before this court. First, as I will address, there is a constitutional right to die. And as Mr. Smith will address, that right extends to allow a third party to exercise that right. Appearance. Appearance is extremely important when you participate in the moot court competition. Dress respectfully. Indeed, dress for success. And you give yourself the best chance for an effective moot court argument. Recap. The top 10 points to remember when competing in moot court are: number 10, apply your facts to the existing law. Number 9, memorize a good opening and closing. Number 8, listen to your opponent and respond. Number 7, stay with your argument. Number 6, preparation is the key. Number 5, be conversational. Number 4, concede when necessary. Number 3, answer yes or no. Number 2, get in and get out. And the number 1 point to remember when performing oral argument at moot court is to have fun and enjoy the experience. I've been through moot court. I know what it's like. I hope that this video helped to unlock some of the mysteries, to give you some comfort in performing a better moot court oral argument. Best of luck to you, and thank you. You know, I don't understand warning labels. You know, they got this can of foamy shave cream. You know, how dangerous can a can of foamy be? I mean, I wouldn't name my dog foamy, but I swear to God, there's a warning label. And on the can it says, and I quote, "Keep away from open flames." Now, how did this label get here? Some nut turned to his wife one day and say, "Honey, I think I'll go in the fireplace and shave." What's the point of that? Then they got other warning labels. They got these things on, what is it, Preparation H? Use only as directed. I mean, how'd this get here? That same nut turned to his wife and say, "Honey, how do you think this tastes on crackers?" Then you got these signs on doors. Do not open while in flight. Now, how'd this get there? That guy turned to his wife, "Honey, I'll be back in a minute." What is it with these warning labels? I don't understand them. You know, they got these other types of things that the stewardesses say. They say, "Please observe the no smoking sign until well out into the terminal." I got news for you. I can't observe the no smoking sign from just outside the door. It's not possible. Then, if 70% of all fatalities occur within 3 miles of your home, how come everybody doesn't just move? I don't understand that. Wrong way signs. How do they know which way you're going? Deer crossing. Who are these signs for? One deer turned next. "We can't cross here, Fred." I was at Kmart last week, I swear to God. It says on the door, it says, "No dogs allowed except seeing-eye dogs." Now, who's this for? Think about it. One dog turned, the other dog saying, "Hey, Rufus, I think we could go in now." Now, these are the things that disturb me. I mean, I'm driving down the street the other day, and I see this woman driving at 90 miles an hour in the left lane. She's got one hand on the wheel, her elbow on the wheel, while she's got one hand putting on makeup while she's adjusting the clock radio on her car, presumably so the coroner will have an accurate time of death as she goes plowing headfirst into the Boy and the Bugle Boys commercial, who's always inadvertently in the wrong place at the wrong time. Hey, you know that guy in the body bag? Is he wearing Bugle Boys? No. Then I was driving here, and you know, I used to have a Dodge Shadow, and it's a great car, but the sun went down, I couldn't find it. It was really a bummer. So I went and rented one of these Geo Prisms. So I rent this red Geo Prism. I get done using it, I bring it back, and when I bring it back, I give the keys to the clerk. She says, "Scott, I thought I rented you a red Geo Prism. This is a blue Geo Prism." I said, No, come over here. Then I bought one of these Mitsubishi Eclipses. Phenomenal car, I gotta tell you. But looking through that piece of foil with the circle in it's a real pain in the ass, I gotta tell you. Just unbelievable. Anyway, okay.
All right. That's good, man.